Mazi Nnamdi Kanu kwechikwalụ n'ụlọ ikpe ukwu dị n'Abuja na a ga-agwụ ya iwu eji ekpe ya ikpe na a ga-agwụ ya ebe edere iwu a ebe kọnstitushọn eji ekpe ya ikpe dị. Ụnụ mana Mazi Nnamdi Kanu kwesịrị ịbanye difensi n'izu gara aga, mana ọ jụrụ wee sị na o nwere iwu eji ekpe ya ikpe, nke bụ na o mechara deje akwụkwọ ka a kagbuo ihe gbasara ikpe ya maka na o nwere iwu eji ekpe ya ikpe. N'ihe onyonyo anụnwa ị ga-ekiri kịta anụnwa, ndị ọkaiwu Mazi Nnamdi Kanu nọgasị ebe anụnwa ma barista Lawyer Ejimakor ma onye omebe iwu nakwazi barista Maxwell Ọkpara kọwalụ ihe Mazi Nnamdi Kanu na-akọ maka ndị aghọtasịrị ọfụma na ebe ọ na-agbado ụkwụ ọ bụrụ na o nwere iwu nwa si na chapta ihe nwa nọ si na Constitution chapter 50 ihe nwa ka ọ gịnị, ebe onye omebe iwu nọkwa ebe anụnwa mepere ọnụ kwuo ha na o nwero chapta dị otu anụnwa dị na akwụkwọ iwu. Unu ga-anụzi nnọọ ka ha si wee kọwaa na ọ bụrụ na Mazi Nnamdi Kanu achọrọ ịbanye difensi kama na a ga-agwụ ya iwu eji ekpe ikpe na ọ bụrụ ịnọkọta itinye na esi anya banye difensi. Tupu ihe onyonyo agwụ nwanne m, ị ga-anụkwazi mgbe ikpe Mazi Nnamdi Kanu ga-adịkwazi ọzọ. Ka anyị nyogodo anya n'ife onyonyo ka anyị jee nụpụta.
To the limited wiggle room of a court of law, of the judiciary, there is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazi Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the power. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in court when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings.
The procedure today?
The proceedings today.
Okay.
What next?
I will use one of my colleagues to discuss that with Maxwell Ọkpara with Isiatu.
Okay, actually, it's good for us to put the record straight. Mazi Nnamdi Kanu is not saying that you not enter the case. Mazi Nnamdi Kanu said, under what law are you charging it? Going by the Constitution, there is absolutely no charge against him. Now tell me the law, that the court should tell me the law upon which he's being tried. Now, my law is on so saying that whatever thing that you have to say should be ruled at the final written address, and it should be on a conviction to know whether they're supposed to be convicted or not. I'm not going to say no. There are thresholds, there are hurdles upon which you need to cross for you to reach that particular issue. And one fundamental issue there is that my law said we are talking about issue of extraordinary rendition, the way we are being brought back from Kenya to Nigeria. And they want somebody to come and give evidence on that. There is nothing before him. And if you watch the motion of Mazi Nnamdi Kanu filed, Mazi Nnamdi Kanu said Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave a ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised. And Mazi Nnamdi Kanu made reference of the motion in the court file. And under the Evidence Act, Mazi Nnamdi Kanu is saying that under the law, court is is obliged, is under obligation to take judicial notice of every document in their file.
Yes.
So asking him now to go and enter into a defense and start giving evidence on that is a waste of time.
Yes.
That court is on its own supposed to take so much to raise this issue.
Yeah.
Court is expected to raise this issue. Now there is a charge before me. Please.
The law that I have contravened. Yes. You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. But honorable, people make that law. It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that the Mazi Nnamdi is completely right and within section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existent.
Ndị be anyị unu anụgoni na ọ bụrụ na Mazi Nnamdi Kanu jụrụ ịbanye defense kama na ọ na-ajụzi kedu law eji ekpe ekpe, kedu iwu maka na o nwere ebe ọ dara iwu n'ihe ndị a na-asị na o mere. Ụmụnne m ebezikwa wee bugharịa anya bụ ikpe ka ọ dịkwazịa mbọchị Wednesday ga-abụ abalị 5 nke ọnwa Nọvemba n'afọ 2025. Ndị nke a mezie n'ihe nke anụnwa bezie n'ife nke unu nukwulu na ihe barrister lawyer Ejimako kwuru na o nwelu kafa ga-esi wee mee ihe anụnwa obe nke kata ma ihe anụnwa ha na-eme evuru na unu nụrụ ọfụma. Ọ bụrụ na igere ntị ịnụ ga-anụ ya na ndị ihe anụnwa ndị ọchịchị obodo na ihe a na fama ka a ga-esi wee mie onye ọbụla udo adị onye enu ma onye anọ ya na o nwere onye ga-enwe okwu ikekwa ndị anụnwa na fu emie ka ọ bụrụzi ife ndọkịrịdị ụnụ mana Mazi Nnamdi Kanu etulugo ugo ebe one ma one amarọzikwa m ife ji nkịta ọnwụ. Ụmụnne m ka m fụ n'efe elu wee sị ka m wefụtara unye n'ime ife niile m ga na-ekwurịtakwa n'udo ga na-achịlị kwudochianụ ndị nke m maka ndị chọrọ udo.